As a brief reminder, this CME activity is jointly provided by the Queens Medical Center along with the University of Hawaii John A. Burns School of Medicine. Joining me this afternoon is our interdisciplinary geriatric echo hub, and I'd like to introduce our physical therapist, Susie Neufeld, along with our pharmacist, Dr. Reese Ueno. We have also Dr. Courtney Nunokawa, our nurse practitioner, and Dr. Lucas Morgan, psychologist, followed by our own geriatrician, Dr. Rita Bell Fernandez. We are excited to share our collective experiences and wisdom and to really learn alongside of you. As a reminder, evaluations for these CME credits, you can find those evaluations by following the link in our chat or at any time on our website and email advertisement. We are currently offering continuing medical education for physicians, Dr. DOs, RNs, the APRNs, and physician assistants. We are also offering NASW continuing education credits for social workers and certificates of attendance for certified nurses, aides, and students. NASW credits, the CEU, will be sent out monthly, usually about a week and a half after this presentation. But with regards to the CME records for the physicians, nurses, and physicians' assistants, you can expect to receive those credits, the report, by mid-January in 2025. So please be sure, in order for you to get that report, you must complete the monthly evaluation forms that I mentioned earlier in the link. As I mentioned earlier, your comments are very important to us. It's helpful for the planning committee and for future programs. This ECHO webinar is a forum for mutual teaching and learning from experts like you on the front lines. Having said that, confidentiality is very important. If you decide that you want to share and have case presentations, please do so keeping in mind that it should be HIPAA compliant. You're not sharing patient names or birth dates. Keep your questions anonymous. Really want to have a place for safe learning and sharing. There's no shame or blame here. As our motto goes, all teach, all learn. And in the spirit of aloha, we encourage you to turn on your cameras to help us build a community of learning. At this time, you may also want to change and rename what your profession is in the box with your picture. Our ECHO webinar format consists of the following. It will be a short lecture from our presenter this afternoon with open comments from the expertise of the ECHO Hub team members I introduced earlier. And you, the participants' comments, your examples of cases, and your questions, we welcome them full-heartedly. So now it gives me great pleasure to introduce our distinguished speaker this afternoon, Professor Jim Pietsch. Professor Pietsch is currently a director of faculty. He's faculty, but also the director of the University of Hawaii Elder Law Program. But a lot of people don't realize he is also holds other faculty positions. He's an adjunct professor with the John A. Burns School of Medicine, Geriatric Medicine Department, adjunct professor of psychiatry with the School of Medicine, and an adjunct professor with the Nancy Atmosfera Walsh School of Nursing. He currently, in addition to all these things and teaching classes, he currently also does a lot of community service. He's on the Queens Medical Center Ethics Committee and a member of Hawaii Legal Services Access to Justice Consortium. Lastly, I do want to thank him for his military service. Professor Pietsch served in the U.S. Army Medical Service Corps, both active and reserve, with Judge Advocate General Corps. Along with him, we're also very privileged to have Dr. Rita Bell Fernandez, who currently serves as a reservist and commander for the U.S. Navy. Thank you and welcome, Professor Pietsch.
Well, thank you very much. I'm very happy to be here today, and I do think it was very appropriate to stop and honor those who were uh, killed on September 11th, and also the thousands that were killed and injured in the consequence of what the attack led to after that. So, thank you very much for that tribute. Okay, so now, now where I should, what we need to do is to trying to look for the screen. All I have are the names of individuals here. So I'm just looking to share the screen. So maybe, maybe we need to, there we go. Is that on your screen?
No, we can't see it. Maybe John will
Okay.
need to pull up your presentation if that's okay with you, Professor Pietsch.
Oh, that's fine with me. It's just that I think we lost the Zoom page. I can only see the, oh, okay. I can see, okay, here we go. All I can see are the names of individuals, the list. Okay, now I can share the screen. Okay, now I pulled it up. Can you see it now?
Yes, we do.
Okay, great. So we're done then. Sorry for the technical problems here. All right. Well, thank you very much. It's wonderful to join the Geriatric Clinic Echo session. I'm joined today by several law students I see on the list because that was all I could see at one point. But I'm going to be talking a little bit about guardianship and conservatorship and a little bit, even a little less bit about the alternatives because we have such a short time for the presentation itself. I'm going to give some general concepts. Guardianship and conservatorship provide the legal mechanism by which the judgment of a more capable person is substituted for the judgment of an incapacitated person. Decisions necessary to manage personal affairs and property. Only a court can appoint a guardian for a ward or a conservator for a protected person. And it should be noted that this should only be necessary if the individual does not have in place suitable alternatives to guardianship and conservatorship, because that's what the main focus should be, is plan for the future so you don't have to go through a guardianship or conservatorship. The court adjudicates incapacity based on testimony by a healthcare professional, which is usually required, psychiatrist, psychologist, geriatrician, or other professional with skills to assess the subject's alleged incapacity. Then the judges balance the concepts that you're very familiar with, autonomy and self-determination, against protection and best interests. The threshold for guardianship and conservatorship is found in the Hawaii Revised Statutes, and it defines incapacitated person as an individual for reasons other than being a minor, is unable to receive and evaluate information or make or communicate decisions to such an extent that the individual lacks the ability to meet essential requirements for physical health, safety, or self-care, even with appropriate and reasonably available technological assistance. The Hawaii courts have jurisdiction over guardianships for individuals domiciled or present in the state, and conservatorships, they have jurisdiction over individuals who are domiciled or own property in the state of Hawaii. So you may have a guardianship proceeding for an individual who lives outside of Hawaii, but has property here. Guardianship cases are usually held in the family court, and conservatorship cases are held in the circuit court. There's a trend these days to combine guardianship and conservatorship cases. They may be consolidated in the circuit court. The probate court is the court in the First Circuit, and on neighbor islands, they have a circuit court. They don't have a separate probate court, so it would be in the general circuit court on neighbor islands. Incapacitated person was defined in the statute with that threshold definition, but we have to dig deeper into see what level of capacity the individual needs, and in particular, what level of evidence needs to be presented to the court in order for the court to appoint a guardian or a conservator. So we'll start off with guardianship. The court may appoint a limited or unlimited guardian for a respondent. That's the individual who's the subject of the question of whether the person is incapacitated and requires a guardian in this case. But the court can appoint the guardian only if it finds by clear and convincing evidence. That's a very high standard of proof that is required, that the respondent is an incapacitated person and the respondent's identified needs cannot be met by less restrictive means, including the use of appropriate and reasonably available technological assistance. For conservatorship, it becomes a little more complicated. The appointment of a limited or unlimited guardian, unlimited conservator or other protective order in relation to the estate and the affairs of an individual, including a minor, may be made if the court determines that for reasons other than age, by clear and convincing evidence, the individual is unable to manage property and business affairs effectively because of an impairment in the ability to receive and evaluate information or to make or communicate decisions, even with the use of appropriate and reasonably available technological assistance, or because of another physical, mental, or health impairment. And then we'll stop there for a second because that you can see the evidence that's going to need to be presented for that portion before we pause here. That's where you healthcare professionals come in, psychiatrists, psychologists. So that will be where you're going to be looking at the abilities of the individual. But conservatorship also applies to individuals who are missing, detained, or unable to return to the United States. So that's missing person. In the movies, they've been missing for 7 years. So you go to court, you don't know whether they're living or dead. Eventually a court can also, under a different statute, declare a person dead for legal purposes. But for conservatorship, it's just a little twist. So you only have to worry about with your patients about the first portion of that. There's a lower level of proof that's required for the next part by preponderance of the evidence. So it's not accurate to say 51%, but that's sort of the concept of preponderance of evidence, that the individual has property that will be wasted or dissipated unless management is provided or money is needed for the support, care, education, health, and welfare of the individual, or if individuals who are entitled to the individual's support and that protection is necessary or desirable to obtain or provide money. So this is where one spouse or the children are in danger because the individual is wasting or dissipating this property. So it's something that you may become involved with, especially in social work, where the family is desperate and the person's gambling money, et cetera, et cetera, et cetera. The IRS uses these statutes also when the individual isn't paying bills, so they can force a guardianship under certain circumstances. Guardianship and conservatorship are determined by the federal government under state law. So they would look to state law that we have here for somebody in Hawaii. Now, how long does a guardianship or conservatorship last? It'll last until the death, resignation, or removal of the guardian or conservator, or when the court determines the guardianship without regard for location of the guardian, conservator, or ward. So when the court terminates the guardianship without regard to location, so they can receive a petition, for example, that they don't want to, that they're for a reason why it should not exist. We've been asked several times from people who are subject to a guardianship, and they say, I take the bus, I go to work, don't go to work anymore, but I'm under a guardianship. And so that person can petition the court and say, look, here I am, evaluate me, or here's my evidence. And so these things do happen for a variety of reasons why they're under that guardianship. They may have regained capacity. That's one reason. Or it could have been due to some sort of trickery. Just a very short sidelight to see how complicated it gets. There's no requirement that the individual be present in court. When we were able to do guardianships, we would either bring the person into court or ask the court to go to the nursing home, for example, because we felt the individual had capacity and should be participating. But that's not a requirement. And so they're served, they don't know what it is, they don't answer, and all of a sudden somebody has a guardianship over them. It's scandalous across the country. There's a GAO report on it, how really bad it is across the country. The last slide, I'll talk more about that. Guardianship and conservatorship positives and negatives. Positives is a court order. Banks for conservatorship, hospitals, nursing facilities, when they see a court order and saying that this person has these powers, they don't want to mess with that. Sometimes they'll want to disagree with the power of attorney or other alternative to guardianship, but court order, that's powerful. Court supervision. Court supervision is a little overstated. They require periodic reports. What happens to the reports? Sometimes I talk with some folks, they don't know what happens to the reports, but they're required. Negatives, that number one line, dollars, dollars, dollars. Very expensive. Attorneys, for this slide, I take off the dollars and I say plus, 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 but it's a big process, time consuming. For guardianships, it's around 6 months. Sometimes you can get a little quicker. Conservatorships, depends on the court. They tend to be perhaps, well, the timelines are very difficult to predict. The main thing that we think about is the potential deprivation of rights and autonomy. Somebody else is put in charge, not somebody you chose, but somebody the court appointed based on a petition by that person or that organization. They may not be making the same decisions that the individual would have wanted them to make. So that's for us is a huge problem, more than time and money. So we advocate for alternatives to guardianship and conservatorship. And this is what our main focus of our program is to give information about what these are, and the handbook that you see in the notes on provided the chat, our website. We have a book, and it talks about alternatives to guardianship and conservatorship. And so this is what we bring to the community. This is what we bring to law students. Law students learn about this. Next week in class, the law students are going to be learning about guardianship, conservatorship. But there are two basic areas of alternatives. The personal, which you can think of, is for what applies to the person's person, and the financial, the real estate, the money. So for the personal, you have legal and financial powers of attorney. I'll add here that the legal and financial powers of attorney can also be used as a power of attorney, can also be used for the financial decisions. The power of attorney is useful in both areas, both spheres of this guardianship and conservatorship. But for personal things applying to the person, and in your major fields, is healthcare, advanced healthcare directives. It's a very important area as an alternative to guardianship. Those of you who work in hospitals especially know that it's very difficult sometimes to get a legally authorized representative to make informed decisions for the individual, or even to discharge an individual. So that would be very helpful to have an agent who is appointed in the Advanced Healthcare Directive, an agent for healthcare power of attorney. And then surrogates under Hawaii law, which is an echo discussion in itself. We have a pretty different statute than other states, but basically there is no family consent law through which an individual who is mentally incapacitated, who does not have an advanced healthcare directive and has never designated somebody otherwise to be in charge of their healthcare decisions, that the family members, the spouse, the children, they do not automatically assume any responsibility. They have to go through especially the primary physicians and other healthcare providers, have to go through a process to have somebody appointed as a surrogate, which requires a consensus of interested persons. Can't always find consensus. For financial issues, bank accounts, real estate, etc., living trusts, they provide a mechanism through which you can not only provide for how you're going to distribute your property upon death, which was a traditional mechanism to avoid probate, to avoid having to go through a will and go through probate, but increasingly in our society with the larger aging population and the sphere of limited capacity and individuals who don't have sufficient capacity to make their own decisions, it's the living trust, because the successor trustee that individual, now incapacitated individual, has appointed in the trust can make all those financial decisions for them. Powers of attorney, I mentioned, under the Uniform Power of Attorney Act, it specifically states that no healthcare powers can be made in that power of attorney. That's why you need an advanced healthcare directive. But powers of attorney can be very powerful documents. Then there are a variety of other basic alternatives, such as joint accounts, property management, things that have been set up. Maybe they don't really need a conservator if they already have all their bills being paid, etc. But the combination of these is probably the best. Supported decision-making is one of the alternatives to guardianship, and it's also part of the future considerations about the future of guardianship. Over a dozen states have supported decision-making laws. Hawaii lags far, far behind in that. So I'll talk about the future, and this will be the last slide. There's a task force that meets. It's been meeting for years now. Advocating for the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act, which is not the law, but it would replace the current law. That law would encourage courts to impose the least restrictive orders possible to adequately protect vulnerable minors and adults, and to monitor the protective arrangement to continuously adapt to an individual's changing capabilities and needs, impose clear duties upon the guardians and conservators charged with protecting others, and requires regular monitoring to ensure compliance. It would allow courts to address specific problems with limited orders and preserve individual rights when possible. And it requires the court to determine whether supported decision-making is an appropriate, less restrictive alternative and not grant that guardianship. But that's the future. It failed to go anywhere last legislature. It's up again. So get ready for a future ECHO presentation. And so there we are. So thank you very much. And now we have a panel discussion.
All right. Well, thank you so much, James. I don't know if you go by James or Jim, but
oh, James, Jim. It depends on the time of the day. That's right.
Yeah. Well, thank you so much. And that was like a little sort of basic orientation for us who do not speak legalese, and into some very complex but really important topics. So really grateful to have you here. I will be monitoring the chat if any questions come up. But first, I'd like to open it up to our panelists and Sarah, from your work in social work, any questions or thoughts about these topics?
Yeah, I was really interested in the last slide, Jim, because I think one of the questions that comes to mind is, I don't know if there currently is existing monitoring, like who has oversight of these guardians on an annual basis. I know for the conservatorship, there we're usually required to submit annually a report of how the funds are being spent. And I bring this up because there's two parts, I guess, to my question is, if there isn't this kind of oversight or monitoring, what I'm seeing, or what I would see in the hospital, is I'm seeing aging adults with developmental and intellectual disabilities. So when they were younger, their family relative, usually a parent who was like in their 30s, 40s, etc., was appointed as a guardian. But now their parents are like 80s. They're hitting like, late 70s, 80s, and they're having their own health challenges. And the problem in the hospital is when you want to do discharge planning with the guardian, well, the guardian may have they have their own cognitive limitations too. So but then the family insists, oh, the mother's been the guardian for 30 years. This is not going to change. And, our hands are sort of tied, but what do you do when the guardian may not have that capacity to perform their work?
And this is a question the Ethics Committee deals with in the respect to healthcare decision-making, when the legally authorized representative or potential one is either not qualified, no longer qualified, or there are problems, or there are some severe issues with the quality of the decision-making or what they're deciding, perhaps in conflict with what the patient had already said. So this is much more than just guardianship and conservatorship. But if there is, if your department, for example, feels that there's an imminent risk of harm to that individual because the guardian is not providing sufficient care oversight of the individual, and the individual is suffering, this may be something
Absolutely.
either to petition the court, but more likely is to think about a report to Adult Protective Services, because they have the right to at least to check on the situation, and they may find, oh, yeah, this is really bad. It could be, just two people in the household, the one taking care of the other, the one with certain disabilities, but the other who was perfectly adequate for years, but now is 100 years old, and said no, and the family said no, he can still take care of mom.
Right. Right.
And, and make decisions for her. So it may be up to that, but no, the proposed law would require monitoring, but there is no monitoring by the court. I mean, there can be if somebody brings it to the attention of the court, and I think that it would be powerful if in institutions or an agency said, what do we do? Maybe bring it to attention court if there is somebody else who can be the guardian. Almost force the issue.
Because if
And
there was monitoring, it wouldn't get to that point.
no, it wouldn't. And that's what that's what supported decision making and the other provisions of the proposed statute would do. So you're absolutely right. We're way far behind. These are problems that weren't really very well addressed when the law was new, but the whole population has changed. It's a whole new world. And you don't have family members who are readily available to jump in anymore as they may have been traditionally in Hawaii.
We have the unbefriended, right? We've spoken about this, the unbefriended, the unrepresented adults, older adults that are never married.
Moved here in the 50s and 60s and are now aging in place. In every major condominium, you have these issues. People are wandering around, don't know what to do, who's going to be the guardian. The public guardian is the default guardian, but somebody has to petition, and they are so overwhelmed with cases too that it's hard even for them to monitor. So it's a big problem. Other states have looked at these issues, and they've decided to spend the money on it, for supported decision making.
Thank you.
Can I follow up
Thanks, Sarah.
From Sarah's question? So usually in the hospital, outpatient setting, we're usually in a time crunch where we're at a place where we need a decision maker. In regards to if the guardian is incapacitated, is a proof of document from their physician needed to nullify the current document, and then we can move forward with doing a surrogate?
Well, what would probably be the most appropriate thing, but it's also time consuming, would be to have, because the hospitals do petition for original guardianships when necessary, but that's something that after you've exhausted everything else. But so then you would sort of go through the same process of finding out, is there somebody who would be willing to serve as the guardian in the family? That would be most appropriate. And then your legal staff would petition the court for a change of guardian to substitute somebody else for that guardian. So you don't have to go through the whole guardianship process. They already proved that the individual is an incapacitated person. They need the help. There's no requirement for that, but now the focus is on the guardian. And so that would be the proof that you would show, the evidence that you would present to the court, indicating that this guardian is no longer fit and the court should replace the individual. And if there's nobody coming forward, the public guardian. It may make it a lot quicker. I'm not sure, but I would suspect that it would be easier because it's a lot quicker type of a case than going through the whole process of proving that the individual is incapacitated and a notice to that individual and all those things. You still have to give notice, but to that individual, but they don't have to go through the whole guardianship process again, just with respect to who's the guardian. Now, the person who is being assisted, who is the ward, that's what the person under guardianship is called, may object and say, no, I want Pops to take care of me, because it may not be they may not have capacity to provide for their own protection, support, make their own decisions. But if somebody would ask, no, I want that, my husband to do it all. So
Jim, what happens if the person, Roxanne's asking too, what happens if the person, the current guardian, they're feeling that that's not the appropriate person, and that current guardian can even argue, because they get an opportunity in court to say they disagree.
Yeah. And that's the American
Roxanne's
system.
decision.
No, but that's the American system. Maybe the guardian's right. So if somebody's petitioning, it may be for other purposes, especially if it involves a conservatorship also. They want the money. We think mom needs to go into a nursing home. Mom wants to stay at home. The guardian says she's staying at home. This is what she wanted. This is what I want. We've been married for 70 years. Maybe not that long, but still. So that's why the judges have to make a judgment.
Wow, very, very complex. Roxanne gave thumbs up. Sounds like you got some use out of that, and that's let's see, Susie.
My hearing isn't probably as good, but I heard one time. No, and it's just because Sarah expects it. It's a little funny thing. I think I heard that I was a junk professor in the geriatric medicine. Well, it's an adjunct, not junk. The adjunct.
No, you're the adjunct.
Oh, okay.
That's good. Susie, you had your hand up, and
I have a question, and this is like a perfect opportunity to ask this, because we have a situation. We provide a free exercise class 2 days a week at a low income housing apartment complex. And there is a participant who comes in. He was asking us about physical therapy. He wants physical therapy. He's had some falls. And so when the therapist started talking to him about it, he doesn't have a doctor. He doesn't have a telephone. He doesn't have a cell phone. It's pretty clear he's got some memory issues. And we're kind of stuck. We don't know what to do about, we want to help him, but what is like the best route, to get this gentleman services?
Yeah. And in Honolulu and all the other islands, I don't know the other islands' contact information, but the City and County of Honolulu Elderly Affairs Division has a senior helpline, and got their book. Let's see. Well, I've got the book, and so it should be in here. Let's see. City and County of Honolulu. Here it is. The County Area Agency on Aging is 768-7700. And then I do have the list of all the other ones, but I won't read them out. But go online, click on it, and it's not that much of an effort. You just go to the very last page, and you have a couple of community resources there. They can start the process of evaluation. Catholic Charities does a great job. Other agencies. Sarah's very much chat with Sarah. I shouldn't have even said that. I said, just ask Sarah. She'll know.
I think the biggest challenge, Susie, is whether your client is wanting whether he recognizes that there is something different that's going on and whether he will agree to accept help.
Yeah.
Yeah, that is the main one. And also, is your organization helping just with the just providing the exercise and therapy and things, or is it overall management of that housing complex?
No. We're there to we provide a free service for exercise.
Yeah,
And then
because
there's a day health agency, day health program on the same campus. So we have asked a social worker to come
okay,
over,
good.
but he works for the state, for this day health facility. So we're just kind of stuck. Like, we're just like, where, what do we do with this gentleman, where we see he's had some issues, and he comes every Monday and Wednesday, and
which is wonderful because somebody's watching, at least those days. But the other individuals in that complex who run the complex or who are responsible for the complex, they should be worried too, because when you're not there, this person may be roaming around and hurting himself, and nobody's there to take care. So it may be if he is so farly deteriorated, it may be something that that could be considered self-neglect too, under the APS statute. The APS statute is not as terrifying to call as you may think, because the number is more than just for abuse, but they also have an adult services section, and they have a financial section, all those things. So they also may be a good resource. And it's not just to report, that there is suspected abuse, but it could be self-neglect if it meets the very strict criteria of their self-neglect. But the person is at imminent risk of death or serious injury if intervention isn't brought.
Thank you for your advice. I appreciate it. We've been
Not advice, just sharing thoughts. That's right.
Okay. Thank you for your thoughts. We've been concerned about him.
Thanks, Susie. And it brings up a question of mine, which is like, you pointed that what if the person isn't interested or willing to comply with an assessment of capacity?
Yeah, this is America. So individuals can say, just leave me alone. And then APS and just had training. Rita Bell can talk about that. But the training session also, they have limits too, and you sometimes, unfortunately, you have to wait until it gets to that point where it reaches a crisis, and that's not the way it should be. But you've got all sorts of people in this country. Some people just are recluses, and they've always been not. But if you see an older person, as an example, you say, okay, well, we need to intervene. But they were that way since they were 18 years of age, and so it's really hard. People can offer, and I think that's what it is. Just some social workers have this knack of just befriending somebody like that, and then they're no longer the term that Sarah used, unbefriended. They've got a friend in this individual who every day just notice, maybe give a cup of coffee, something of that nature. So they have secret ways of enticing people to help themselves.
I just had a case that I would want to bring up, and I was talking to the patient of mine was the son of a woman who was seen very clearly incapacitated. They're both living at home. Son was maybe 60 and the mother was maybe 80. Son was the primary caregiver, very low resource family. And the mother had, from his report to me, pretty advanced or advancing dementia of some kind that would take pretty sort of violent turns, unfortunately. So like threatening him with a knife or throwing her chamber pot of urine on him or around the house, and refusing any sort of assessment. And we were talking about how can he have more control over her care. And cops are called repeatedly, adult protective services called repeatedly, but we ran into this challenge where adult protective service was like, we can't establish her lack of capacity. And so we were, I was just curious what you would recommend, like who could go into the home and make evidence that she doesn't have capacity, therefore he should have some control over what happens to her. I don't know. What do you think?
Yes. So it's not the individual who is so you've got the son who's taking care of the parents. Now, who is the one who is acting up and doesn't want? Is it the son or is it the mother? So the mother said, just, I don't want anybody in here, or does she act that way towards her son and to her husband?
No more husband, but the son, tries to get her to the doctor's appointment, and she's just like, nope, not going anywhere, not going to let anyone in the house. And so she's the one. Yeah.
Of course, we would recommend APS, but they've already been there. They can order an assessment if they feel that the individual lacks capacity.
So they order an assessment, and that means someone comes to the home to do it.
The appropriate medical care assessment. It could be they take her, but that's APS. I can't speak for them.
They'd have to like drag her into the car.
What their process is. I don't think they would do that, but
right.
But they do, and one of our guests in our elder law clinic, who used to go along with APS on their rides, and I've been along with them too. It's a fascinating world out there. So they may bring somebody like that on their next visit, and the individual, a psychologist could probably, think of, well, your preliminary, this is what I see just by what I see in her responses to me. So it may be worthwhile to talk with them, and to maybe negotiate another visit, maybe with a psychologist or psychiatrist. But I don't know what their process or procedures are.
Yeah. Okay. Well, thank you. It's a tough one. Well, I noticed the time.
And then one other thing is throwing urine and potential stabbing knife. This implicates something much more serious. This could be not under guardianship, conservatorship, although APS statutes. It could be under our mental health statutes, Chapter 334, involuntary civil commitment, where a person is imminently dangerous to self or others. So Queens, other major facilities, they deal with this. They have special units, and the police are well aware of how to deal with it. But they mental, Kakela ward, those type of things, if necessary. But that you might want to talk to those folks. The mental health portion, the people that you deal with, to see how they would initiate that, because one day she may kill the son. So I would say public safety, and it's a separate statute, and there's separate. I mentioned that the standard of evidence for guardianships, for example, is clear and convincing evidence, very high standard. For that, you even have a higher standard. It's usually used only for criminal statutes, clear and convincing evidence that the individual is an imminent threat to self and others. They have a whole criteria of what that means. So it might be under Chapter 334, involuntary civil commitment, hospitalization, and treatment.
Gotcha.
So I would worry if knives are out.
Yeah, and we had him take away all the sharp objects in the house after that happened. But you're right that the threat is still there. So
and because they could also be threatening their own lives.
Yeah.
And so if it gets to that point, the son can call the police or 911 and ask, what's the emergency? I'm afraid my mother's trying to kill me, or she's going to kill herself imminently.
Yep. Well, thank you. Appreciate that statute. Well, looking at the time, sorry we didn't get to the other panel folks. If anyone has anything they want to add or ask about, panel or otherwise, there's been a lively discussion in the chat, it looks like. Just opening it up here in the last few minutes. If anyone wants to.
I have one more question for Jim. Jim, oftentimes people are looking for attorneys that they can, if they have the financial resources to submit, a petition for guardianship, because it's about what, $5,000 if a person's doing it in the community. What resource can people go to find lists of elder law attorneys or attorneys
Yeah, there's an elder law section of the bar, and there's also family law section. So it's the intersection of family and elder law, because guardianships are much more than just for older people. It's also for younger people who lack capacity for a variety of reasons, developmentally disabled, injuries, accidents, no longer mentally capacitated, minors. So the Hawaii State Bar Association does have a legal information and referral service, but a caution there is that the attorneys who subscribe to that, it's a subscription. They pay to be on that list. Many attorneys do not want to be put on that list. They have enough business from word of mouth. The professionals who deal with these type of issues, doctors, healthcare providers who know who's been reasonable, who's been attentive, who's been quick to respond, who's been acting nice after an interview. Those type of individuals may be the best. At the university, I can't provide any recommendations because we don't provide recommendations. If we did, we know that other people who have provided recommendations, the person turned out not to be so good, or their case went bad and they blamed the attorney, not the facts, or they blame somebody. So best to stay out of the referral business. But there are many individuals out there who do guardianships, and then one way is to have your hospital send you to court one day and just look at the attorneys that are handling the cases, see how they act. But it's like in Hawaii, as with many things, personal injury, all those, they're very good. Others who may not know what they're doing, they subscribe, they say, oh, I'm desperate for anything. So they'll sign up for everything on that list for the referral, but they may or may not be qualified in all those areas. So how's that for a lawyer answer? It took a long time to answer and gave you no assistance. Okay. But I'll charge you.
Good enough. Well, yeah, I'm sure you would.
Okay, well, thank you everyone for being here today, and really important, fascinating, complex topic. Thank you so much, Professor Pietsch, for being here and sharing this.
And I might add that this is not legal advice. It's my personal thoughts, not of the university or of anybody else, but also it's just the surface level. And so it's very complex, very complicated. So don't take everything and say, okay, we're going to go in this direction. So seek professional legal advice from your facility You have great attorneys in the hospitals, for example. So they know these things. They know the attorneys that they hire, for example. Who do they hire to do guardianships? So ask them. And the social work department says, okay, we know you can't petition because it's not for informed consent in the hospitalized person needs discharge. But who are good? Who are the ones that you're dealing with, and maybe we can refer our clients to them. So I think that might be a good way. Sorry for the interruption.
Great ideas. No, thank you. And thanks everyone. There's John, tech support, has put the link to the evaluation for CME credits in the chat. So please do that if that's also what you're looking for. Well, big mahalo again to you, Professor Pietsch, for being here and really just scratching the surface of this really important, complex topic for us.
Thank you for having me. Appreciate it.
Big mahalo. Everyone have a good rest of your week and hope to see you here next month.
Okay. Oh, well, not me. That's for your audience, but it might be. No,
maybe.
I'm registered. I'm registered, so I'm ready to go. Okay.
All right. Take care.